The acting attorney general is supposed to be the people's lawyer and defend the rule of law and not act as the president's personal lawyer. But in this administration, the Department of Justice is solely focused on pleasing one man, no matter the cost. Lest anyone forget, huge banners with Donald Trump's face hang from both sides of the main Justice building. This is the big banner of Donald Trump on one side of it, so that every single person who enters that building will see it and remember exactly what that man wants them to do. You're his former personal attorney, and you know exactly what he wants. In fact, he often posts it right here on social media, his Truth Social account. He wants to weaponize the department for his own political ends. And right from the start, you and your cohorts have worked to deliver what he wants, doing his political dirty work.
A budget hearing is supposed to be boring by design, the kind of room where officials talk about staffing, operations, enforcement priorities, and how many taxpayer dollars they need to keep the lights on. But this one opened like someone had pulled a campaign poster off the wall and found a warning label underneath. Giant Donald Trump banners outside the main Justice Department building. An acting attorney general named Mr. Blanche asking for public money, and Senator Van Hollen accusing him of turning the Department of Justice into a legal service desk for one man. That is not a small charge. That is not a normal partisan jab. That is an allegation that the people's lawyer has been replaced by the president's personal lawyer with federal power in his hands. And Van Hollen did not ease into it. He framed the room immediately. Mr. Blanche was supposed to defend the rule of law, not Donald Trump's political hunger. He reminded everyone that Blanche had been Trump's former personal attorney, which made the entire scene feel less like a routine budget request and more like a conflict of interest hearing hiding inside a spending hearing. Because when the same official asking for taxpayer funds is accused of using those funds to punish Trump's enemies, reward Trump's allies, and chase Trump's vendettas, the question is no longer administrative. It becomes constitutional. The shocking part is how many pieces Van Hollen put on the table before the room could even settle.
You even suggested that there was, quote, a ton of evidence that the 2020 election was rigged against Trump. And here you are at a budget hearing asking for taxpayer funds to pursue the department's mission when you're using those funds to punish Trump's adversaries, reward his friends, and pursue his personal vendettas. It began with pardoning the rioters who stormed the Capitol on January 6th and assaulted police officers. The revenge continued with the firing of more than a dozen lawyers who represented the Justice Department in those cases. Yesterday, you created a $1.8 billion slush fund to dole out taxpayer dollars to the president's supporters, including those who attacked this Capitol on January 6th. That is pure theft of public funds. And rewarding individuals who committed crimes is obscene. Every American can see through this illegal, corrupt, self-dealing scheme. You have also misspent resources on the blatant political prosecutions of James Comey and others. You couldn't find a single career lawyer to bring the first case against Comey, and lawyers resigned rather than participate in that charade. Now you've launched a ludicrous vindictive prosecution in the Seashell case. It's a shameful dereliction of your duty to pursue impartial justice without fear or favor.
He pointed to pardons for January 6th rioters, the firing of Justice Department lawyers, a claimed $1.8 billion fund for Trump supporters, political prosecutions, journalist charges, immigration judge firings, and a department that reportedly lost more than 8,500 staff in 1 year. That is the core of this opening statement, not one scandal, a pattern. And the question hanging over the hearing was brutal. Is Congress funding a Justice Department or financing a private revenge operation with a government logo? Then Senator Van Hollen moved from accusation to evidence, and this is where the hearing stopped sounding like politics and started sounding like a prosecution table, being loaded exhibit by exhibit. He did not just say Mr. Blanche was biased. He built the case through action, money, personnel, and timing. First came January 6th, the wound that still sits in the center of this argument like broken glass under a carpet. According to Van Hollen, the pattern began with pardoning the rioters who stormed the Capitol and assaulted police officers, which means the first signal from this Justice Department was not accountability, but reward. And that is where the contradiction becomes impossible to ignore. A Justice Department cannot claim to defend law enforcement while blessing the people accused of attacking law enforcement. It cannot ask police officers to stand in front of violent crowds, then turn around and politically sanitize the violence once the cameras move away. That is not just a legal contradiction, that is a moral insult dressed up as policy. Van Galen's point was clear. If the government rewards the people who broke through the doors, then every officer who held the line is being told their sacrifice was negotiable. Then came the firings. Van Galen said more than a dozen lawyers who represented the Justice Department in January 6th cases were fired. And that detail matters because institutions do not collapse only when leaders make speeches. They collapse when professional staff learn that doing the lawful thing may cost them their careers. A prosecutor is supposed to follow facts, evidence, statutes, and court obligations, not guess which defendant is politically favored by the president.
Others in the department have been fired for telling the truth to the courts, an insidious message to send to officers of the court. You have fired immigration judges who rendered decisions the administration didn't like. More gross political interference in what is supposed to be an independent process. All told, DOJ lost over 8,500 staff last year and nearly 1/4 of its lawyers. It's so bad that you're now offering $25,000 signing bonuses and hiring prosecutors with no prior legal experience, seeking applicants who personally pledge support to the president. You've also refused to share with members of Congress the Office of Legal Counsel's purported legal justification for the blatantly illegal war the president and Prime Minister Netanyahu started in Iran.
So when career lawyers are fired, or when lawyers resign, rather than participate in what Van Galen called a charade, that is not workplace drama. That is smoke coming from inside the engine room. The next receipt was money. Van Galen accused Mr. Blanche of creating a $1.8 billion slush fund to distribute taxpayer dollars to the president's supporters, including people connected to January 6th. That allegation hits differently because this was a budget hearing. Blanche was not standing there as a commentator on cable news. He was asking for public funds, and Van Galen was effectively saying, why should Congress hand you more money if the money becomes a political reward system? In normal life, that would be like hiring a security guard after watching him hand your house keys to the burglar because the burglar was loyal to his boss. Then Van Galen turned to prosecutions, and the same pattern reappeared from another angle. He accused the department of pursuing blatantly political cases against James Comey and others, saying they could not find a single career lawyer willing to bring the first case against Comey. That detail is powerful because career lawyers are not YouTube pundits, campaign influencers, or rally speakers. Their job is to look at evidence and decide whether a case can survive in court. When the professionals step away, when resignations begin, when the only path forward requires bypassing the very people trained to protect the credibility of the case, the question becomes obvious. Is this prosecution or is this performance? And Van Galen did not stop there. He pointed to a ludicrous, vindictive prosecution in the CL case, criminal charges against journalists working in Minneapolis, and a refusal to hold accountable DHS agents involved in the death of Renee Good. At the same time, he said the administration called Renee Good and Alex Prey domestic terrorists, while Mr. Blanche ordered a criminal investigation of Renee Good's partner. That is the ugly logic Van Galen wanted the room to see. Power moves away from accountability and toward retaliation. The people with badges get insulation, the people asking questions get pressure, and the people already harmed get turned into targets. By the time Van Galen mentioned immigration judges being fired for decisions the administration disliked, the argument had grown larger than one case.
This is especially true with respect to the cases of the survivors of the heinous crimes committed by Jeffrey Epstein. Many of those survivors are in New York City today as we speak, as part of a 24-hour public reading of the Epstein files. Many reading excerpts from their own FBI 302 reports documenting the abuses they endured.
This was no longer about whether Mr. Blanche made one bad call. It was about whether the Department of Justice, under his watch, had started treating independence itself as disobedience. Because once judges, prosecutors, lawyers, and court officers understand that legal judgment must bend toward political approval, the rule of law does not need to be formally repealed. It simply gets replaced by fear. One personnel decision at a time. Then Senator Van Hollen widened the lens, because the damage he described was not limited to prosecutions, pardons, or firings. He pointed to the human structure of the Justice Department itself, and that may be the quietest but most dangerous part of the entire statement. According to Van Hollen, the Department of Justice lost more than 8,500 staff last year and nearly 1/4 of its lawyers, a number so large it does not sound like routine turnover anymore. It sounds like an institution being emptied from the inside, then rebuilt according to loyalty instead of competence. And when Van Hollen said the department was now offering $25,000 signing bonuses and hiring prosecutors with no prior legal experience while seeking applicants who personally pledged support to the president, the implication was not subtle. That is where the internal contradiction becomes almost absurd. A Justice Department cannot say it needs more money to enforce the law while allegedly weakening the very professional culture that makes lawful enforcement possible. It cannot drive out experienced lawyers, punish court officers for telling the truth, fire immigration judges for decisions the administration dislikes, and then ask the public to trust that everything is still normal. That is like setting fire to the courthouse library, then requesting a bigger budget for legal research. The problem is not just money. The problem is whether the people spending that money are still serving legal duty or political appetite. Van Hollen also raised the issue of the Office of Legal Counsel and the alleged legal justification for the war started in Iran by the President and Prime Minister Netanyahu. That detail matters because the Office of Legal Counsel is not supposed to be a private shield for executive power. It exists to define what the government can legally do, especially when war, force, and constitutional authority are involved. So, when Congress asks for the legal reasoning behind a military action and the department refuses to share it, the silence itself becomes part of the evidence. What was said in the room was serious, but what was not said may have been even more revealing. Because Van Hollen's entire statement kept circling back to one question: who is the Justice Department protecting from scrutiny? It was not just about Donald Trump's public demands on Truth Social. It was not just about Mr. Blanche's past role as Trump's personal lawyer. It was about the conflict between a private-client relationship and a public constitutional duty. When a former personal attorney steps into the role of acting attorney general, every major decision involving that former client has to be cleaner, more transparent, and more insulated from suspicion, not more secretive, more aggressive, and more politically convenient. And then came the moral center of the hearing: Jeffrey Epstein's survivors. Van Hollen said many survivors were in New York City that same day, participating in a 24-hour public reading of the Epstein files, including excerpts from their own FBI 302 reports documenting the abuse they endured. That image changes the temperature of the entire statement. Outside the hearing room, survivors were reading the paper trail of their own trauma into the public record, trying once again to force powerful institutions to hear them. Inside the hearing room, Van Hollen accused Mr. Blanche of spending 2 days interviewing Ghislaine Maxwell, Epstein's convicted associate, before she was moved to a lower security prison camp with special perks. That contrast is devastating because it puts two versions of justice side by side. On one side, survivors are asking to be heard, with documents in their hands and scars that never needed political permission to be real. On the other side, a convicted associate of Jeffrey Epstein receives high-level attention and, shortly afterward, a softer prison placement. Van Hollen did not need to over-explain the moral problem. He only needed to place the images next to each other. When victims have to read their pain aloud in public while power gets private meetings, the system is not just failing procedurally. It is telling the country whose voice still counts. And that is why this hearing cannot be reduced to one party attacking another party, or one senator trying to score one viral moment against one official. The deeper issue is whether the American legal system still belongs to the public, or whether it can be quietly converted into a private weapon for the most powerful person in the room. Senator Van Hollen's statement was not subtle, and it was not meant to be subtle. He looked at Mr. Blanche and essentially said, "You are asking Congress to fund justice, but your record shows punishment for enemies, comfort for allies, secrecy for power, and contempt for the people who trusted the law to protect them." That is the kind of accusation that does not disappear when the hearing ends, because it touches the central promise of a republic. My view is simple. The rule of law does not die only when someone announces its death. It dies when public offices become personal instruments, when prosecutors are rewarded for loyalty instead of judgment, when career lawyers are treated like obstacles, when judges are punished for independent decisions, and when victims have to beg for attention while insiders receive private access. That is the lesson here. A justice system can keep its marble buildings, its official seals, its flags, and its formal titles, while the meaning behind those symbols is being hollowed out from the inside. And once citizens begin to believe that law is only strict for the powerless and flexible for the connected, the damage is not just political, it is civic poison. So the final question is not whether Mr. Blanche survived one hearing. The final question is whether Congress, the courts, and the public will treat this as a warning sign or just another loud afternoon in Washington. Because when a Justice Department is accused of serving a former client instead of the Constitution, silence becomes a choice. And if the law can be bent for one man today, who exactly is protected tomorrow? Like, comment, share this video, and subscribe for more breakdowns of the hearings where power is finally forced to answer in public.